Our next presenter, Jack Sharman, is going to raise and answer the question, what can corporate internal counsel and advisors learn from an impeachment investigation of a state governor? Jack was involved as serving as special counsel to the Alabama House Judiciary Committee for the impeachment of its governor, Robert Bentley. He oversaw a months-long investigation, litigated in multiple courts, and presented his findings to the committee. Governor Bentley ultimately pled guilty to 2 criminal offenses and resigned. You'll hear the lessons for corporate counsel and internal investigations that Jack learned from the impeachment investigation of the governor. Please welcome Jack Sharman from the Lightfoot firm.
In our few minutes together this morning, I want you to listen to the stuff about sex, but I want you to pay attention to the stuff about power. It's sort of come for the sex and stay for the power. Because if we do that, we'll figure out how an impeachment investigation might be relevant to corporate internal investigations. First, a little bit of background. Robert Bentley was a 70-year-old dermatologist from Tuscaloosa, Alabama, and a deacon, the First Baptist Church of Tuscaloosa, and also the most unlikely governor in recent Alabama history. His senior advisor was Rebecca Mason, a married woman, not his wife, with whom he began a relationship. Diane Bentley, Governor Bentley's wife of 50 years and the First Lady of Alabama, discovered this relationship and was displeased. Ms. Bentley's chief of staff was a young woman named Heather Hanna. For NFL fans in the room, Heather is the niece of All-Pro offensive lineman John Hanna, who played many years with the New England Patriots. Ms. Hanna showed Mrs. Bentley how to use her iPhone to record her husband's telephone conversations. Ms. Bentley did that and captured a number of telephone conversations between the governor and Mrs. Mason.
I love that. I do love that. When I stand behind you, and I put my arms around you, and I put my hands on your breast, and I put my hands on you, and pull you in real close. I love that too.
There is more, but I will not inflict it upon you. Governor Bentley also proved to be inept with text messaging. He did not realize that the state-issued iPad, which he gave to Mrs. Bentley, would sync with his own iPhone, such that every text he sent to Mrs. Mason immediately and simultaneously went to Mrs. Bentley. Again, I will not burden you with the details, but a reasonable example is as follows: Governor Bentley being in blue, Mrs. Mason being in gray. You look beautiful and feel so soft, you sweet thing. I'm so in love with you, we are pitiful. Poor Rocky, poor Robert, poor Rebecca. And in a response that is now ensconced in Alabama politics, yes, bless our hearts and other parts. Governor Bentley responded, magnetic, and Mrs. Mason said, we're not going to make it. The texts were not the problem, though, because the governor learned of the existence of the tapes and over time became obsessed with them, first blaming Heather Hanna, threatening her and pointing out that in Alabama people fall at his throne. More significantly, on the eve of Ms. Hanna's testimony before the Alabama Ethics Commission, which was one of 3 entities investigating these claims, the other 2 being us and a special prosecutor appointed by the Alabama Attorney General, her car was vandalized. If you can't read it in the back, it says, "Bitch, die." Governor Bentley became increasingly desperate to find the tapes. And he began using law enforcement to try and find them, including the chief of his dignitary protection unit, the man there named Ray Lewis. And it was the misuse of law enforcement rather than the sexting that got our attention as a potential impeachable offense. As we dug further, we found that the governor sent state troopers to shake down former and current staffers to try to determine the location of the tapes. He attempted to create a special investigations unit within the Alabama Law Enforcement Agency designed to gin up a criminal case, if possible, against Ms. Hanna. Now, articles of impeachment were referred in the Alabama House. The matter was sent to the Judiciary Committee. My Lightfoot colleagues and I were hired as special counsel to conduct an investigation. We began impeachment hearings on Monday, April 7th at 10 a.m. By 4 p.m. that afternoon, Governor Bentley had pled guilty to 2 criminal offenses, 2 misdemeanors, and had submitted his resignation. So all of that is racy stuff. There are even T-shirts now for sale that say other parts. But what, if anything, can we learn from this process for corporate internal investigations and how we conduct them? Well, there were actually more parallels than I would ever have thought. First, who is our client? That old law school chestnut about knowing who your client is critical for corporate internal investigations. For my purposes, my client was the Judiciary Committee personified by its chairman, Mike Jones, technically. In reality, I had 15 clients, 15 members of the committee, legislators with different agendas, different experience, different levels of sophistication. In a corporate internal investigation, we have the same problem. Who is the client? Is it the company? Is it the board of directors? Is it an audit committee of the board of directors? If there's a derivative lawsuit, is it a special litigation committee? Who are the people to whom we're reporting? And that's not only important for privilege reasons, obviously, but it's also important for the structure and the substance of what our investigation report might actually be. All right. Secondly, at the beginning, take time to assemble the right team. Smart lawyers are not good enough. You have to have people who have the right predisposition and experience. The reason I got hired was not because of my bow tie. I got hired because, in part, many years ago, I was counsel to the House Banking Committee for the Whitewater investigation of then President and Mrs. Clinton. On our impeachment team, we had a former federal prosecutor from the district that encompasses the state capitol. We had a former Wall Street analyst to deal with the financial papers. And we had a former Marine helicopter gunship pilot, just for general principles. It's also important in a corporate internal investigation to think early on about what arenas, what forum might we be working in. In the impeachment investigation, we had 3. We had committee meetings and hearings. We had litigation. The governor sued in the Alabama Supreme Court to stop the release of the report and also to stop the House from actually holding hearings. We pointed out that the former is a prior restraint on speech and the latter violates the separation of powers and ultimately prevailed. And then third, our third arena was the public, media in general and social media in particular. In a corporate internal investigation, there are going to be the same types of considerations. For example, is there a grand jury investigation? Is there a threatened or actual parallel civil lawsuit? Is there a regulator or an enforcement action pending? Are there shareholders, communities, or other stakeholders who need to be addressed? All of that is going to, again, shape the structure of what we do and our determination of not only what we produce, but in what form and to whom we ultimately owe it. The narrative. Get ahead of the story. This is something I had never actually understood or thought about until this job. In any corporate internal investigation, there's going to be obviously a private and internal narrative, a private and internal story. But oftentimes, especially in one of some significance to the company, there may be a public and external narrative. And we need to get control over, or at least influence, both of those. How do we do it? In the impeachment investigation, we knew a couple of things. One, our story had to be simple, had to be straightforward, and of uncompromised and unchallengeable integrity. Secondly, we had to have a way to get the source material quickly and easily to the public in general and to the media in particular. How did we do that? We created, I didn't do it, but it was created for us, a web page. About a third of you are playing with your phones and not paying attention anyway, so go ahead and go there now. It's Bentley Investigation. It's bentleyinvestigation.com. And this webpage, for which, again, I take no credit, was powerful and potentially outcome determinative. In the first 36 hours after it went live, we had 16,000 downloads of our report, not visits, downloads. And it allowed us to modify and to a large degree control the narrative. All right, another point is limitations. In a corporate internal investigation, just like an impeachment investigation, there are limitations on what we can get done, and the consumer of our product, the business unit, the board, whatever it is, needs to understand that. In the impeachment investigation, for example, a significant point of contention was whether the committee, the Judiciary Committee, could actually enforce its own subpoenas itself. And we had significant noncompliance from important actors, including Governor Bentley. Similarly, in a corporate internal investigation, the business unit, the ultimate consumer, needs to understand that this is not magic. And you and the investigators and the lawyers don't have magic tools. For example, there is no grand jury. And so there's going to be information that probably cannot be reached. Everybody needs to be on the same page about that before you start. Upjohn warnings. I know it sounds simple, but in an internal investigation, give your upjohn warnings. This was brought home to me because the main argument, sometimes the only argument, that the governor's lawyers offered was that the investigatory process and the proposed impeachment hearing structure did not satisfy due process. There's lots of legal reasons I won't burden you with why that's not so. The main one being that, as you know, an impeachment is essentially a charge. And in Alabama, as in most states and at the federal level, the impeached constitutional officer then has a trial in the Senate with the senators as seated and sworn jurors. Nevertheless, the governor's argument had some gut appeal to it. Similarly, an employee in a corporate internal investigation has no due process rights. On the other hand, he or she does have a right to unconflicted representation. And a failure to hew to clear and vigorous upjohn warnings can have terrible effects for the employee, but can also end up disqualifying counsel from representing the company, and that could have some bad effects. All right, so finally, as Governor Bentley packs up, and to your delight, I prepare to leave you, what possible things could we take away from this investigation? First, be sure that the texts that you mean to send to your mistress go to your mistress and not to your wife. But secondly, and perhaps more importantly, pay attention to the blocking and tackling of internal investigations. Know who your client is, get the right team in place up front, control the narrative, know the limitations of yourself and the people who are working with you, and make sure everybody's on the same page about that, and pay attention to the basics of process like upjohn warnings. If you do all that, you'll be okay. Thank you.